Welcome to the law offices of Chris M. Ingram's Immigration News Show. Today we ask, is USCIS ignoring your EB-1A proof? We would like to thank attorney Chris M. Ingram and staff at the law offices of Chris M. Ingram for their hard work in preparing the research for the show, which draws on a wide variety of news sources from both sides of the aisle, providing a balanced view. Attorney Ingram is also a vocal advocate for the rights and protection of immigration applicants, although our coverage is designed to be nonpartisan. Please don't forget to like, follow, and subscribe to our channel. We are also on Spotify, YouTube, LinkedIn, Facebook, X, Reddit, and Instagram, where we're growing rapidly thanks to our social media team. You can also visit our website on www.breakthroughusa.com. We'd love to see you there. Disclaimer. Please note that this presentation should not be intended as legal advice for your specific situation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughusa.com and schedule an appointment. We'd love to hear from you and help you if we can. We'd also like to point out that this presentation was created using AI hosts. Okay, let's dive in. Looking at the docket for today, based on the research from attorney Chris Ingram's team, the theme that really jumps out at me isn't just immigration updates.
No, it's something bigger.
It feels more like we're looking at a system in the middle of a massive identity crisis. We have courts striking down longstanding rules. We have the H-1B Lottery completely changing its underlying math.
In an economy that is simultaneously firing people and desperate to hire them.
Exactly. It's a lot of mixed signals.
It is a chaotic moment, absolutely.
Yeah.
If you are a STEM professional, someone in engineering, data science, biotech, you're living in this weird duality right now.
A duality?
Yeah. Your skills are globally liquid. You can code or research pretty much anywhere in the world.
Right.
But your physical presence in the United States is tied to paperwork. It is becoming incredibly specific and, frankly, a lot harder to predict. The margin for error is shrinking.
And that is exactly why we're doing this deep dive. The goal isn't just to list news headlines, but to find the strategy inside all the noise.
Right.
We have 4 distinct files to get through today. First, we are going to look at what some call the entrepreneur's loophole.
Though that might be a misnomer.
It might be. It's a specific way H-1B holders are starting companies without, breaking the law.
And we have to talk about the Mukherjee ruling. This is a huge federal court decision about the EB-1A, the Extraordinary Ability Green Card.
And it challenges the final merits test, which I know has been the bane of high-skilled applicants for over a decade.
A long time. We've also got the new math for the H-1B Lottery. Fiscal year 2027 is introducing a weighted selection model.
We need to explain what that actually means for your odds, because it's no longer just a random drawing.
Not at all. And finally, we'll zoom out to the macroeconomy. Layoffs are hitting tech again in early 2026, but AI is also driving hiring.
We need to talk about how to, recession-proof your visa status using what attorney Ingram calls paperwork resilience.
Sounds good.
Okay, let's start with that entrepreneurship angle. This is probably the most common question found in the firm's research. I have a full-time H-1B job, but I have a startup idea. Can I pursue it?
And the conventional wisdom on the street is a hard no.
Yeah.
People think the H-1B ties you to one employer. End of story.
You work for big tech company A, and you go home.
But that is an oversimplification. The research shows that while you can't be employed by your side hustle without a separate visa, you can own it.
Okay, let's define that distinction. Because employed versus owned sounds like legal semantics, but practically speaking, it's a minefield.
It is a minefield, but it's one you can walk through if you know where the mines are. Let's look at the case study of Devjit Saha. He's a perfect example our team highlighted.
Right.
He was working at Oracle as a software engineer on an H-1B. He wanted to build Home Abroad, a platform to help immigrants get mortgages.
Which is a massive problem to solve, by the way. I mean, trying to get a loan when your credit history is in another country it's a nightmare.
A total nightmare.
Yeah.
But as an H-1B holder, he couldn't just quit Oracle and become the CEO of Home Abroad, right?
Yeah.
Exactly.
Yeah.
That would be unauthorized employment. If he engages in the day-to-day labor coding the website, making sales calls, managing staff, running payroll, that is work.
And his visa only authorized him to work for Oracle.
So if he does that for his own company, he violates his status. As simple as that.
So how did he get around it?
He used the concept of passive investment. He co-founded the company, he owned equity, and he provided high-level strategic direction.
But he didn't act as an employee.
Precisely. He didn't take a salary from the startup. He hired others, citizens or green card holders, to do the actual operational work.
Strategic direction. That sounds a little vague. Where is the line? I mean, if I'm in a board meeting saying we should use Python instead of Java, is that work or is that ownership?
That is the gray area where you need what attorney Chris Ingram calls courage and precision.
Okay.
Generally, acting as a shareholder, voting on major decisions, hiring a CEO, setting the long-term vision is allowed. That's what investors do.
But if you're debugging the code at 2 a.m.?
Or answering customer support tickets, you are crossing the line into labor. Saha was incredibly disciplined. He kept his Oracle job to maintain his status and used the startup as an investment vehicle.
So the takeaway for our listener is you don't have to kill your startup idea.
No. You just have to structure your role differently. You're the investor, not the worker.
Compliance becomes a design constraint of your business model.
Exactly. You have to build the business in a way that allows you to be hands-off operationally, as Attorney Ingram puts it. Your immigration journey is not a measure of your worth. It's a system you learn to navigate with courage and precision. If you're building in STEM, your discipline today becomes your freedom tomorrow.
Discipline becomes freedom. I like that.
Yeah.
Now, speaking of strict rules, let's shift gears to the EB-1A.
The green card for people with extraordinary ability. The Einstein visa, as people sometimes call it.
Right. And the appeal is obvious. No employer needed, no labor certification, no perm process. You save, what, 2 years?
Easily 12 to 24 months. You skip that whole part where you have to prove no U.S. worker can do the job.
You just have to prove you are one of the small percentage who has risen to the very top of the field.
It's a purely merit-based argument.
But the problem, and the research highlights this heavily, is this two-step analysis. Can you break down what that actually is? Because this seems to be where everyone gets stuck.
Sure. This comes from a 2010 case, Kazarian v. USCIS. Before this, things were a bit more fluid. But Kazarian established a very rigid framework.
Okay.
Step 1 is the math. You need to meet 3 out of 10 regulatory criteria. Things like winning nationally recognized prizes, having a high salary.
Original contributions, judging the work of others, that kind of thing.
Right. And that's objective. Can you count to 3?
Okay, so if I have 3, logically, I should get the green card.
You would think so. But then comes step 2, the final merits determination. This is where the officer looks at the totality of the evidence and decides, subjectively, if you have sustained national or international acclaim.
That feels like a trap. It sounds like, congratulations, you passed the test, but I still don't feel like you're smart enough.
That is exactly how applicants describe it. It feels like circular logic. You meet the criteria, which are supposed to prove extraordinary ability, but then they say the criteria aren't enough to prove extraordinary ability.
It allows for a lot of discretion.
A ton. And often, inconsistency. But there's a major new crack in this wall. The research team flagged a case called Mukherjee v. Miller.
This is the journalist, Anahita Mukherjee.
Yes, she applied for an EB-1A. USCIS actually admitted she met 5 of the 10 criteria.
5. That's way above the threshold of 3.
Way above. But then they denied her at step 2, saying she didn't have overall acclaim.
And she sued.
She sued. And the U.S. District Court in Nebraska ruled in her favor. But the reason is what really matters here. The judge didn't just say she is extraordinary.
What did the judge say?
The judge said the final merits test itself, as USCIS was applying it, violated the APA, the Administrative Procedure Act.
We hear APA a lot in legal news. What does it actually have to do with immigration?
The APA is essentially the rule book for how government agencies make rules. It stops them from just making things up on the fly.
Okay.
And the court said that by creating this extra final merits hurdle, USCIS effectively made a new rule without going through the proper notice and comment process. They skipped the line.
So what happened?
The judge vacated the denial and ordered them to approve her.
That seems huge. Does this kill the final merits test nationwide?
Not automatically. This is a district court ruling in Nebraska. It's not a Supreme Court ruling.
It's not a silver bullet.
Now, technically, it binds USCIS only in that specific jurisdiction. However, it gives every lawyer in the country a loaded weapon. If you get a denial based on final merits, you can now cite Mukherjee and say, look, a federal court has already called this methodology unlawful.
So it shifts the leverage back to the applicant.
Drastically. But you still need to do the work. The research notes that fees are going up. Premium processing for the I-140 is hitting $2,965 for cases postmarked after March 1st, 2026.
You really don't want to pay that twice.
Absolutely not. So the strategy isn't to just rely on the court case, but to build a petition that is undeniable from the start.
So you don't just list a membership.
Right. You prove the association requires outstanding achievement to enter. You don't just show a judging invite. You show why you were selected. Contextualize everything so they can't use step 2 against you.
Rome, 20,000 spectators, one epic battle, 2 warriors, one destiny. But before they can fight for glory, they must face the real challenge, getting their visa approved.
If you want to enter, show me your visa.
They should have went to the law offices of Chris M. Ingram. They are very good.
Yes, I've heard the same. They handled my visa in no time.
Off to the Lions pit.
Come with me, boys. It's dinner time.
Because even legends need the offices of Chris M. Ingram.
Are you looking for a visa? Why don't you get your free consultation on the Breakthrough website? We're with you every step of the way.
As Attorney Ingram says about this ruling, if you've earned recognition through real work that advances science and serves people, don't let a confusing denial define your future. The right strategy is built on evidence, clarity, and the courage to keep moving.
The courage to keep moving. I think that leads us perfectly into our next segment, because if there's one group that needs resilience right now, it's those waiting for the H-1B cap season.
Oh, absolutely. The research team has the specific dates for the FY2027 cap season. Let's get those out of the way first.
Good idea.
Registration opens at noon Eastern on March 4th, 2026, and it closes at noon Eastern on March 19th, 2026.
And notifications should be out by March 31. But the big story here isn't the dates, it's the mechanism. The Department of Homeland Security has issued a final rule, effective February 27, 2026, that implements a weighted selection process.
Weighted selection? This sounds like a huge departure from the random lottery we're all used to.
It is a fundamental shift.
Right.
Previously, if you registered, you had the same chance as anyone else, assuming you had the degree. Now the selection is weighted based on the highest OEWS wage level that the offer equals or exceeds.
OEWS. That just sounds like alphabet soup. Break that down for us.
It stands for Occupational Employment and Wage Statistics. It's how the Department of Labor categorizes salaries.
Okay.
They divide every single job into 4 levels based on geography and duties. Level 1 is entry level. Level 4 is, fully competent senior.
So how does this new rule use those levels?
Under the new rule, registration for a level 4 wage has a higher statistical probability of being selected than a level 1 entry level wage.
So money talks.
In a way, yes. The government is using wage level as a proxy for skill. The stated goal is to favor higher skilled and higher paid aliens.
So a level 4 offer has a statistically better chance.
A much better chance, yeah.
That seems like it would create a massive disparity between different types of employers. What if I'm a massive tech company?
If you're Google or Microsoft, you can easily pay level 3 or 4 wages. No problem.
But what if I'm an early stage startup or a nonprofit researcher?
You are at a severe disadvantage. Startups might offer incredible stock options, but the H-1B system looks at the cash wage relative to the OEWS benchmark.
So a brilliant engineer at a startup earning a level 1 base salary because they have a ton of equity might lose out.
To a middle manager at a bank earning a level 3 salary. Exactly.
Wow. So if you're a student or an applicant, simply having a job offer isn't enough anymore. You have to know how that job is classified.
Precisely. Sloppy classification is now a major risk. Employers need to align the compensation and role very, very precisely.
All in the details.
It is. And for students, especially those on F1 visas, this just reinforces the need for parallel tracks.
You mean looking at other visa options?
Yes. Don't put all your eggs in the H-1B basket. Use your OPT and STEM OPT time to build evidence for an O-1 visa or an EB-2 national interest waiver.
Because those don't depend on a lottery.
Weighted or otherwise.
Yeah.
Exactly. It's about having a plan B and a plan C.
Attorney Chris Ingram sums this up perfectly in the research. In STEM, you're trained to plan with data, not panic, and immigration should be no different. When the timeline is tight, preparation becomes peace.
Preparation becomes peace. That's a great mantra.
But let's zoom out a bit. We've talked about the specific visas, but all of this is happening against the backdrop of a very strange economy.
It is a paradoxical economy. The legal team's research points out that we're seeing massive layoffs in early 2026 companies like Amazon cutting 16,000 corporate roles.
Yet at the same time, there's a fierce demand for STEM talent. How does that make sense? Cutting jobs but hiring talent.
It's what economists are calling a sector rotation inside the companies themselves. They aren't just firing because they're broke, they're restructuring. They're cutting layers of management, HR, and routine administrative roles to free up capital.
To buy GPU clusters.
Basically, yes. They are dumping capital into AI infrastructure. And that changes who they want to hire. If your job is managing a process, you're vulnerable.
But if your job is deploying a model, you're gold.
Exactly. They are cutting the middle to build the future.
And for an immigrant on a visa, a layoff isn't just a career setback, it's a ticking clock.
That's the danger. If you're on an H-1B, you have a 60-day grace period. That is 60 calendar days, not work days, to find a new sponsor or leave the country.
And on OPT, it's even stricter.
You have very limited unemployment days. Layoffs trigger these timelines instantly.
And with AI entering the mix, the nature of the work itself is changing too.
It is. The research indicates that AI is replacing routine tasks, drafting, support tickets, basic coding. But it creates a huge demand for model deployment, data governance, and cybersecurity.
So the strategy for our listeners is to position themselves in those safe zones.
Correct. You want to move toward roles that are harder to commoditize. Applied research, robotics, complex systems architecture. And beyond the technical skills, you need what our team calls paperwork resilience.
What does paperwork resilience look like practically?
It means your documents need to be ready today. Do you have copies of your I-797 approval notices? Do you have your pay stubs for the last 3 months downloaded and saved locally?
Because if you get locked out of your company laptop tomorrow morning...
Can you prove your status to a new employer by the afternoon? That's the question.
That is a chilling thought, but vital preparation.
And you need to be able to pivot your narrative. Position yourself as the person who manages the AIs, not the person the AI replaces.
It's a lot of pressure, but it's also a reminder that this talent is desperately needed. The U.S. economy needs these people.
Absolutely. We cannot build the next generation of technology without global talent. As attorney Chris Ingram notes, immigrant talent doesn't compete against America. It strengthens America. When STEM immigrants can keep building here, innovation expands, companies grow, and communities thrive.
So let's bring this all together. We've covered a lot of ground today. We talked about Devjit Saha proving you can innovate within the rules.
We discussed the Mukherjee ruling pushing back on unfair denials.
We looked at the new weighted H-1B lottery and the shifting economy. The common thread here is turning uncertainty into structure.
It is. Passive reliance on the system is dangerous right now. You can't just trust that the lottery will pick you, or that the officer will see your merit, or that your company won't restructure.
You have to take control. Structure your side projects like Devjit Saha. Structure your green card evidence like a scientist to survive the final merits test.
And structure your H-1B application to maximize your wage level points.
Exactly. Uncertainty is inevitable, but vulnerability is optional. If you keep your documents organized, understand the new rules, and pivot your skills toward where the economy is going, you can navigate this.
I think that's the perfect place to wrap up our analysis. It's about agency. You have more power than you think, provided you use the rules to your advantage.
Agreed.
I'll leave the listeners with this final thought from attorney Chris Ingram. You belong in the future you're building. Stay steady, stay informed, and keep your dignity intact, because your work has value and your story is still unfolding.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together. Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this material for our presentation. See you next time on Let's Talk U.S. Immigration. Bye for now.